Yes, Monsieur.
Yes. So we're dealing with the question about...
Just about getting through exhaustion, aren't we? Just about getting through exhaustion.
We're getting exhausted by this issue. It was just... Can I just mention briefly a case that my learned friend relied upon, as I think as an analogy in this kind of area, which was Dalkia Utilities. It's one of the cases about terminating a contract. And I think the issue in those cases was that there had been some kind of repudiatory breach by one of the parties. The other party could have terminated under the terms of the contract for that breach, or you could terminate common law for it. He attempted, or the company attempted to terminate under the contract ineffectively, so they got it wrong. The question was, could you spell out of that a termination, an attempt to terminate under common law? And they said you could. But of course that's a wholly different situation, because there the actions are unilateral, both unilateral actions by the innocent party to the contract. They have the right to do one of these two things, and the only question is, having tried to do one and failed, do you spell out that they have actually done the one that they could have done?
Do you want to take us to the case?
Yes, certainly. Yeah, it's at page, it begins 1681. It's an Authority 2A, tab 32. It begins on 1648, but the passage is 1681. It's paragraphs 143 and 144. And particularly, you can see in 144 the conclusion there.
Where do we stop reading?
Well, 143 and 144 are the two passages.
Okay.
Paragraphs.
Yes.
So we would submit that that doesn't form any kind of analogy for a situation where one party unilaterally attempts to carry out some action like varying the contract and fails to do so. It doesn't follow, this is not an analogy with the situation that happens, and you could then say, well, we must be taken to have done it consensually. Because it would require there to be an agreement. A better analogy, we would say, is the case of Beasley and Hallwood type case, which was I mentioned before, which was about the option, and that's on page 1554. The point was there that there was an attempt to exercise an option which was exercised invalidly. And then subsequently the other party acted on the basis that the option had been validly exercised. They assumed that it had been validly exercised. And one of the questions...
Valid or an invalid?
So the other party assumed that it had been validly exercised and acted on the basis that it had been validly exercised, but in fact it hadn't.
So we want to go to 558.
So it's particularly 558, exactly. And it's the first short paragraph and then the second larger paragraph on 558.
So it wasn't the exercise of the option was invalid, the whole option was invalid.
Yes, for non-registration, I think.
Yeah.
Yes, sir.
So what is the bit you're drawing our attention?
So it's the paragraph, it's the fact that what the judge says is about halfway down, two-thirds of the way down the big paragraph, any transaction between two or more parties can, in my judgment, only result in a contract between them if they enter into that transaction with an intention to create binding contractual obligations, or in circumstances in which an intention must be attributed to them. The facts of the present case negative such an intention, for those letters were written with the intention of carrying out what were thought to be existing obligations, not of creating any new obligations. On this ground, no contract was shown to have been established. So what he's saying is the fact that the two parties act...
558?
This is on one... No, it's on one...
No.
Sorry, the passage is on
1563.
63.
Oh, okay.
So 558 is the page in the report.
Oh, I see.
It's the
Yes, I see.
So you can't spell a contract out of the fact that the other party appeared to agree to it because he thought he had to agree to it because he thought that there was an obligation on him because of the option. I think that's the point the judge is making. So you can't say to somebody, I purported to exercise an option, it turned out to be invalid, but you went along with it, therefore we must assume that you agreed to it. Which is, I guess, common sense, really. You can't. Otherwise, you would be creating a contract because both parties were under the mistaken belief that one of them had validly exercised a unilateral power or option or whatever.
There seems to be a limit to how far you can push that, though, because if you take our case, if it's, for the purposes of argument, is assumed that the notice given under Clause 12 is invalid. So, in fact, although they didn't appreciate it, the contractor was at liberty to either agree or not agree to go on to build the building.
Yeah.
Either on the 1st of April 2011 or quite shortly thereafter. I mean, one can debate when it happens, when they keep the money. They know that that money is for the building. They know there's a whole set of terms in accordance with which it's being assumed that if they build, they will have to comply. Even though the background to that situation may have arisen through mistake. Does one not reach a point where, whatever the background was, they know fine that they're now going to be bound into the future, and it almost becomes irrelevant whether that mistake was made or not?
Well, this is where this, one answer to that is this is where this sale and development agreement comes in, because we can see under that they have agreed to carry out the works. So there isn't any problem. If you're asking a commercial question, there isn't any problem in this particular case. I agree, if they hadn't entered into this agreement and they'd just gone on to build the building, you might have an interesting question as to whether there was any contract.
Well, it could be a varied contract, it could be a new contract, it could be an estoppel by convention. It could be a...
Yeah.
You might analyse it in different ways. But
Yes.
In fact, I was seeking to focus on actually a new contract analysis, because they haven't exercised what was the contractual power under Clause 12, which would have left the contractor on the hook whether they liked it or not. They thought they had, but they didn't. This is just for the purposes of this argument.
Yeah.
But they have made it, the employer has made it very clear they actually do want this building built. If at some point the contractor keeps the money, knowing that they've been given the money in order for that to be achieved, my instinctual feeling would be that the contract probably arises at that point.
Well, can we just look at perhaps we should look
one
at
can debate then how you characterise it in terms of variation, or it's a new contract, and that leaves at large what might be significant for the purposes of application of the statute. But just in terms of pure contractual analysis, instinctively I want to say at some point that there is a new contract, which I think is very much what my Lord Richards was putting before, if I understood him correctly.
And we don't dispute that, and we say positively that there was a contract entered into, which was on the 4th of April, and it binds them to do the work, and and to procure the work without any further payment. So it seems quite clear, we would say, although they were under a mistaken belief that the exercise was valid when they entered into this, and that the payment had been made under the valid exercised instruction, you can still easily see from this that the contractor, who is called the principal contractor in this document, has actually agreed again, if they had agreed before.
I'm not sure
they've agreed, so there is a contract to do all
for the
this.
purposes of this argument, it matters whether the SDA comes into the picture or not. I suppose the SDA is never entered into, but the contractor keeps the money beyond a day or so in circumstances where, in effect, in terms of, I don't know, crossing the line or whatever, it amounts to an indication to the other side, we're happy to proceed on this basis.
Or indeed weeks later that they start to get the work done at some point.
So I'm not sure that the SDA may be relevant for other parts of your argument, but just in terms of analysing precisely what happens on the first... Well,
as I understand it, what the LLP say is that this kind of analysis, that there was a contract arose because of what you say, but it arose from day one, and that the money was paid under that contract. As an answer to that, I'm saying that simply is not a correct analysis of the facts of this case. That any contract that did come into existence came into existence on the 4th of April, and it was under that contract that the works was done. Under that contract, the contractor procured the work to be done by the subcontractors, who of course did the work under other contracts that were entered into subsequently. So, but the whole framework for that is the SDA. So that's the only reason I emphasise that is to answer the point which is being made, I understand, by the LLPs, that you have to imply a contract, including the payment of the £54 million from day one, and that expenditure therefore was incurred under that contract. So that has to be their case.
So you're not agreeing, as I understand it, with what I understood to be the Court of Appeal analysis, which was that, putting to one side the SDA, there is a new contract. Putting to one side the SDA.
Yeah.
Put that out of your head. Well, that, as I understood it, is what the Court of Appeal said ultimately. That was their decision, that it wasn't a variation, it was a new independent contract drawing in terms from the Golden contract, but not dependent on the SDA. But you wouldn't accept that?
No, I would say, it's a matter of stages. If we get to the stage where it's said that there was a contract under which the 54 million was paid, according to the LLP's analysis, I would still say that is a new contract. That's where we get to Morris and Barron and whatever. We only get there once you have a contractually agreed variation of the Golden contract, which is what the LLPs say there is. And the Court of Appeal were prepared to assume that, because they said even on that assumption, we still win because that is a new contract.
I have to say, I understood when you were answering my questions that you were saying it was leave aside the SDA if you're just spelling out a contract, if that's the right analysis, from the payment of the 54 million and it being kept on a clear basis, that was a new contract.
Yes, I do say that, yeah. But I'd say you don't get that far because the contract is actually the SDA. So these are...
That is your fallback. So the Court of Appeals analysis is your fallback position if we're not with you on the SDA.
In a sense, there are a number of different stages, a number of reasons we say this fails, and yes, exactly.
Oh, right, because I understood you to be saying there was no contract. I thought the argument on the 1st of April was there was no contract.
Oh, on the 1st of April, no contract. The SDA is entered into on the 4th of April. That's my argument.
SDA, I think we're all interested in, if you are wrong on the SDA point, what is your case then?
Well, our case is that any contract that came into, any variation thereafter at that time was a new contract.
That is a legally questionable statement. Either it's a variation or it's a new contract.
Well, sorry, any alteration,
again, then.
any alteration of the golden contract consensually by the parties amounted to a new contract and not a variation of the original contract.
Either on the 1st of April or sometime after, given that they didn't hand the money back, or at any time.
Yeah.
Right.
Just to bottom this out as best we can, I think you're saying it doesn't happen on the 1st of April because just receipt of the money doesn't involve any counter indication of acceptance of promise or counter promise by the contractor. All you've done is something's happened to you. That can't be read in itself as a promise to the other side. But if, as time goes by, it becomes clear you're going to keep this money, and it's clear that the money's been paid to you on a particular basis, at the point it becomes clear you're keeping it, and therefore must have accepted you're keeping it on that basis, that is sufficient for counter obligations to contractual obligations to come into effect.
It could be, and yes, that could be. And we're
But I think you're saying...
We're ignoring counterfactually the existence of the SDA.
I think you're saying, before you got to that point, although it could have been arrived at, you have the interception of the SDA. So that's why you then focus on the SDA. And the previous way of putting it is your fallback rather than the other way around.
Yes, well, I think it was always in the sense of, I wouldn't like to say a fallback, it's just a number of different reasons why, even if they're right about this, it fails. That's the way I would put it.
Okay, thank you.
I mean, that's the way that the Court of Appeal, I think, essentially put it. They decided that although there might be something in these points, they didn't need to decide them because even if it was a contractual variation, a contractual alteration, then it would be a new contract. That was their conclusion.
Do you? I quite understand you say, well, this isn't a variation; it's a new contract. Do you also say that even if it varies and keeps alive the old contract, it's still itself contractual, and that's the contract for the purposes of construction of the Act, that under which the expenditure is incurred? Do you go that far?
I don't think I go that far.
Okay.
If it wouldn't be said under the Morris and Barron type principle.
Okay.
Then I wouldn't go.
Thank you. Well, where next?
Okay. Well, I don't know. Perhaps we should just look at the SDA. Just since I keep mentioning it, I'm sorry about that. And then we can move on to what is probably the issue that most interested this court in giving permission, I imagine, which is Morris and Barron, etc. So, if we look at the SDA, it's on page 668 of the bundle.
668.
668, yeah. Well, that's where we get to the operative part of it. Before then, you can see there's a lot of definitions.
I'd like to see who the parties are.
Oh yes, that's probably helpful. It's the developer and the contractor, who is now
Which
called...
page is that?
Sorry?
Page?
656.
Thank you.
Oh, I see. It's also on 659. Yes, okay.
I see.
Yeah.
So,
It's on 659. Yeah.
oh, is it?
659 is the beginning of the contract.
I see, yes. principal contractor.
So yes, so we have the developer, who was the one who was called the employer under the golden contract, the principal contractor, who is the contractor under the golden contract, and then the owner. Well, there are two other companies involved for minor reasons, but the owner is the LLP, who are coming into the picture now. So what this agreement does is, as it suggests by its name, it implements some sales and the development. So if you go to 668, first of all we have the lease of the land, which the developer holds at that stage and is being assigned to the owner, the LLP. And then it says the developer has agreed to procure the construction of the building and procure the carrying out of the building works for the owner on the terms recorded in this agreement. So it appears that this is the agreement that will govern the development. And then, in consideration of the obligations on the part of the developer and the principal contractor to carry out and complete the building works in the manner set out below, and the developer enter into its obligation under the service agreement, then the owner grants various licenses, etc. So there isn't any problem, we would submit, in the principal contractor being obliged to carry out the building works.
Well, you don't get that, I don't think, out of clause 2.3, because that's an obligation or a covenant by the development to procure.
It's 2.4.
2.4. You took us to 2.3.
Oh, sorry, I was reading 2.4. The developer and the principal.
Of the obligations on the part of the developer, I see. So
to carry out and complete the building works in the manner set out below, which is in this agreement.
yes, presumably somewhere we see stated the obligation of the principal contractor to carry out and complete the building. Is that right?
Well, the manner set out below there are various clauses. Various clauses after that which place obligations on the principal contractor to do things. I think one of them, as Lord Burrows pointed out, was to perform all the obligations under the various contracts and not be paid any more, because of course the idea was they'd been paid already, as you can see in 2.5. The belief at that time was that sum had been paid under the principal contract, which is the golden contract.
What then is the price on page 665, which is 153.7 million?
That's a different thing. That is.
What is that then?
Well, that is 3. So the owner, that is the LLP, purchased an assignment of the benefit of the golden contract from the developer for 153 million odd. And it's that sum, I'm sorry that nobody's explained this to you yet, but it's that sum on which the LLP are claiming capital allowances. But they can only claim it if essentially the developer can claim capital allowances in respect of the money that's paid for the development. That's the way the statutory provisions work. So although we've been looking at the 54 million and whether that's incurred under a contract, that's all for the purposes of deciding whether the LLPs can claim capital allowances on their 153 million that they paid for the benefit of the golden contract. It is all explained in the lower courts when they go through the legislation. I don't know if you want me to do that again, but that is number 3, consideration. The developer assigning the benefit of the rights under the principal contract pursuant to the deed of assignment and fulfilling all obligations, the owner pay the price to the developer.
But doesn't that presuppose that the construction work is going to be done pursuant to the principal contract.
Oh, it does, yes, because they all believed, as I made clear, everyone believed that the principal contract was the...
But where is the...
varied.
Well, I'm still not quite sure that I've grasped how the principal contractor comes under a separate obligation under this agreement.
Well, because they have an obligation under 2.4 to carry out and complete the building works in the manner set out below.
So if they weren't actually doing it under the principal contract, they're bound to do it some other which way.
They're bound to do it under the manner set out below, not in the principal contract, but in the manner that's actually set out in this contract.
Well, that's the manner set out below is as per the principal contract.
No, it's not,
Pursuant
because
to the, is it?
there are lots of provisions in this that are not in the principal contract about subcontractors, etc.
I see.
There's loads of provisions here about how to actually build, how actually to have the building procured and built.
I see. Right.
For instance, if you just look ahead, you'll see, without this document, it wouldn't be possible for the project to take place because it's got all the detailed provisions about
I see.
fit-out contracts, about the shell contract. So, for instance, if you look at number 5,
Paragraph 5.
paragraph 5
Oh,
and 670 at the bottom, a copy of the terms of the shell contract agreed between the developer and the principal contractor and approved by the owner is annexed to Appendix 11.
Now, what is the shell contract?
That's the contract to build it
shell.
to shell and core. Yeah.
That's separate from the golden contract.
Well, that is the actual. I think that's going to be the actual contract for the. I think that's for the subcontractors. Is that right? I think to build the actual shell and core.
Right.
So that's been agreed between the developer, the principal contractor, and approved by the owner.
So if
That's not part of the golden contract because the owner is not involved in the golden contract. Obviously, it's not in part of that. This is a separate set of agreements to build
yeah, I see.
the buildings. So you can see within that there's a whole procedure for selecting the subcontractors and tendering and that kind of stuff, which you obviously need to build. And then there's the same kind of thing for the fit-out contracts. And then there's a lot of terms about various accounts that had to be opened because I'm not going to go into the details of this, but it was relevant for other parts of this case. But the 153 million went various ways into different accounts. One of them being the shell construction account, which is referred to in 675, which was a way of financing. There's a very complicated process of financing this, which we've had to look at in relation to other issues in this case. But this is undoubtedly, you can see just by looking through it, it's a very detailed contract for building the actual building and fitting it out when it comes to it. And we would say...
It looks like... I mean, I've got some difficulty analysing exactly what this contract does in relation to the principal contract, which keeps on being referred to, the principal contract that is between the developer and the
Yes.
and the contractor. It looks as if there's a sort of overlap.
The
I don't
problem...
think one is substituting.
The difficulty is we
completely, is it?
don't know because, I'm sorry to go back to this, but what we don't have is the detailed employer's requirements that purported to be issued under the change order. So we can't actually tell how different this is from what was in that document.
Right.
But it's going to be a lot greater, we would submit, inevitably, than what was in that document. And also it involves the owner, who is now in the picture. And
Yes, but it might not be more detailed as regards the actual building of the shell. Might be identical.
Well, it might or it might not be, but I think it's unlikely that it was identical. But we don't have any evidence as to what it was.
It was just that I think you were making the submission that the building couldn't be built without this. All I'm saying to you is I'm a bit unclear as to whether that's necessarily the case.
Well,
Because it may well be that we've got fully worked out shell contract between the principal contractor and the developer under which it could be built.
No, I don't think that's the case, because what was said in the evidence, although the witness couldn't tell you what exactly was there, he did say it would be rather like the employer's requirements, which we do have employer's requirements in relation to this contract. And he said, but that's only, the employer's requirements are only a part of it. He didn't say it would be the same terms, he just said it would look like, the employer's requirement. There are later employer's requirements in relation to this contract to build the building. So no one was saying that it would include all these other terms and shell contracts, etc. Because these are things that are done afterwards. So it was never the evidence that it would be anything like this.
And all this goes just to this point, does it? That if you can get your mind into the hypothetical counterfactual world that these parties didn't think that the notice to proceed was a perfectly valid implementation of rights under the Golden Contract, they shouldn't be taken as having intended to vary the Golden Contract, because everything that needed to be said and done was already in an advanced stage of negotiation under this document, and in fact finally entered into 3 days later.
It's not necessary for you to imply, if that's the right term, a contract.
That's all it goes to, I think, isn't it?
That's all it goes, but it's quite, I mean...
I'm not trying to...
Yes, it's what it goes to. I'm sorry, my lord, absolutely what it goes to. It goes to a reply to the argument that there's no way that this building could have been built unless we imply a contract, which is what they have to say, I think, to imply a contract. They have to say there's no way that this building could have been built unless we imply a contract in the terms that of the invalid notice, essentially, as being a contractual agreement between the parties, although they didn't actually agree it at the time. That's what it goes to. It's a reply to that point. And of course, if it's a good reply, then that's the end of things, because there is no contractual variation, alteration, which could be a variation or a new contract. This issue, which I'm just going to turn to, simply doesn't arise.
Can I just ask this? Let's suppose there was no SDA. The facts are as we have them, and then 14 days, on the 14th of April, the contractor is advised, actually there was no power under Clause 12 to do what has been done, for the instruction to be given. You are under no obligation to do the work, none of which has yet been done. And if you return the 54 million, that's it. You're free of the obligation. Is that what you would say would be the position? Supposing nothing had happened after the 1st of April, and then, let's say 14 days later, the contractor received this advice, do you say that the contractor would then have been entitled to take that step?
Yes, he would be legally entitled to do that, yes. Whether they would in practice, obviously they wouldn't in practice. Yes, legally entitled. And if they purported then to enter into an agreement with the developer to vary the contract, then all the issues that we're just about to discuss would arise.
Yes, of course. Yes. Yes.
So I was going to then turn to what I think is my final issue. And we would submit that a lot of the confusion in this issue, right up to this code, has come from a different use of the word intention. What is meant by intention? And there is quite a good discussion of this by Lord Wright, who is quoted in one of the cases in the bundle, which is Sir Lindsay Parkinson, and it's at page 1357. it's in the primary authorities. I don't know if that makes any difference to you. 1357. And it's the passage that begins just after where he cites Inland Revenue Commissioners and Raphael, if you see that on 1357. And then the quote goes down to the middle of the next page. I think what he's talking here is actually about construction.
Where do we stop?
Well, if you can just finish the quote, probably best.
Yeah.
Now, there has been some debate about whether there are two steps or not in this process. In my submission, on any view, there are clearly two stages to this process, this kind of process. One must be a matter of construction of the contract and of the purported variation.
Sorry, when you say two stages to this process, what process?
The process of deciding whether a purported variation is actually a variation of the contract or actually a new contract, or whether it affects rescission, which was an issue in earlier cases.
Would it be better to say deciding whether the changes that have made to the earlier contract amount to a variation of that contract or a new contract?
Yes, I only use purported because generally in these cases the parties are often trying to vary the contract. But you're right, my lady. I'm happy to accept that. Whether the changes, whether changes or alterations that are made to a contract amount to a variation or a new contract. But there are inevitably two stages. One is a matter of construction of the contract. What does it mean? What do the terms mean? And that's done on normal contractual construction principles. And the second stage must be to decide the question as to whether, having decided what they mean, whether this amounts to a new contract or a variation of the original contract.
So stage one, when you say construction of the contract, which contract are you talking about?
Both the original contract and the alteration, because what the cases say is you've got to look at both of those. Got to look at what was.
Well, you've got two sets of contractual obligations.
Yes.
The original ones and the subsequent ones.
Yes.
And you've got to compare those.
Yes, but the first step, it may be a step that is easy or not. But the first step must be to construe these two sets of obligations.
And then, sorry,
and
then what's the second stage?
The second stage is that you then have to apply whatever you think is the appropriate test, and that's what we're looking at. We say it as a question of comparing the terms and looking whether there was a sufficiently fundamental change to amount to a new contract. But you have to apply that, whatever the test is. So there must be two stages. The only question is what does the second stage require? And as I understand the case that's been put, intention of the parties is the end of the question in the sense of an actual intention as to what the result would be of what they've done. So in this case, their intention, my friend says, is looked at objectively or subjectively, whatever you look at it.
Well, objectively.
Looked at it objectively, yep. It was for the tax scheme to work, so that there would be a variation. They would get the tax relief. That's what the upper tribunal said, that it must be assumed that they would do would have done whatever was necessary to get the tax relief.
I see.
That's what they said. They're assuming that the parties, that's why they're there, these parties, to get the tax relief. So that's the argument. And they say it doesn't matter how great the alteration is, as long as the parties intend objectively it to be a variation, then it is a variation. So intention in that sense is everything. What we say is that when the courts are talk about intention in various cases, intention of the parties, what they're talking about is the intention of the parties that's manifested by what they have agreed. That's what they mean, and that's how they explain it. So it's not their actual intention, but it's what intention they have manifested by what agreement they had originally and what agreement they've now made. And that's how it's tested, and that's exactly how it was done in what the House of Lords did in Morris and Barron.
But I understand that you address question of intention on an objective basis, but don't you do so in the context of a particular factual matrix or set of circumstances? And if both sides of the contract know that the prime purpose of the contract is to achieve tax relief, why is that not an objective circumstance against which one can assess their objective intention?
It's an objective circumstance, but what we would say is that as a matter of legal analysis, that would only come into play if what they had done was, if you like, maybe equivocal, if it was an unclear situation as to whether there was a variation or a new contract.
Would you be applying a linguistic test?
You start by applying a linguistic test in the sense of comparing what's been done,
as a matter of language.
Well, as a matter
Did you take into account surrounding circumstances in comparing what they've agreed and what's been changed?
Yes, if what they've changed is marginal, so it could be it's difficult to determine whether it could be a variation or not, then what they have manifested by saying we intend this to be a variation could be relevant. I can accept that much.
But why isn't the tax situation one of the circumstances which you use when construing the agreements, even before you get to whether it's a variation or a new contract?
Well, one of the problems with that is the problems I listed earlier, which is, are you talking about the actual tax position, or are you talking about the tax position they think?
No, well, all right, I see the point.
That's the problem.
But that's not an answer to saying you ignore tax, is it?
Not an answer to say you ignore it, but an answer to say you don't let it rule the...
No, I'm unclear whether you say the tax consideration is wholly irrelevant, or whether, as Lord Justice Newey said, it was relevant but not determinative.
Well, let me put it this way. First of all, I would say it's clearly relevant at the first stage. If you're construing a contract, you can take into account the surrounding circumstances, including that they were attempting to achieve a certain purpose.
Because we're looking at the objective intention of the parties.
Exactly, yeah. in construing the contract.
Yeah.
But you said the first stage covers both the original contract and the second contract.
Yes.
So if you can look at the purpose
to decide what they've done.
Spectacles, why does that not lead you to the conclusion, well, they intended it to be a variation because that's what they needed it to be for tax purposes?
Well, at this stage, we're only looking at what they've actually agreed as to what the contract means, if you like, not the effect of entering into that agreement. Because we would submit that is a matter of if you're deciding whether there is one contract or two, that's a matter we would say of legal analysis, not a matter of the parties deciding.
So you say intention is irrelevant at that stage, do you?
Intention No, not
At the
well.
stage
If you mean by that what they were trying to achieve.
No, I mean whether it's a variation or a new contract.
No, sorry. When you're talking about intention,
Sorry.
because I think
Start
this is,
again. Let's start again, just so I'm clear.
Yeah.
I think you accept, indeed you must accept, that intention is the objectively intention is the guiding principle in construing both the original contract and the purported variation.
yes.
What I'm unclear is whether you say intention objectively ascertained is relevant in deciding, or is the guiding principle in deciding whether you've got a variation or a new contract.
Well, it's certainly not the guiding principle. As I think I said, it could only be relevant if what they'd actually done, in other words, what they'd agreed, could be a variation or could be a new contract, and you couldn't.
So how is not? I see.
That could be a
you see. Well, you say that Morris and Barron supports you on this.
Well, Morrison Barron doesn't address that question because
It's absolutely littered with references to intention.
but all of it is talking about the intention deduced from what they said, because all of it involves a comparison.
Is that right?
Between, yes, it is.
Sure.
If we look at the case, you'll see that all of the judges are comparing the original contract and the letter or whatever it is that.
Well, Lord Palmer says that the determining factor is the intention of the parties at the time when the parallel arrangement was made. This question is one of fact and depends on the conclusions to be drawn from the acts and conduct of the parties.
Yes, exactly. And the action and conduct of the parties is what they've agreed,
I see.
not what they wish to happen.
I'm so sorry, but people make agreements usually for particular commercial purposes. You know, that's, on my understanding, part of the approach to objective interpretation of contracts is that you have some sense of the commercial objectives that the parties were trying to achieve, and you read the words of the contract in the light of those purposes. You know, in fact, that's the factual matrix.
Construing it.
So when you come to the second of the agreements, why isn't a commonly understood appreciation of the tax position that for the second agreement to preserve the right to ECAs, it needs to be a variation, not a rescission? Why is that objective circumstance not relevant to the interpretation of what the second agreement is intended to and does achieve?
Well, it's relevant to. Well, we would say it's relevant to what the second agreement does in the sense of what the agreement is, and what they're doing under it. But it's not relevant to the legal analysis as to whether this is a separate contract or one or the same contract, because that's not a question that the parties determine by their.
But it was put against you, I think, that. Let's put it this way: is there a clear authority that establishes that objective common intention isn't also relevant in determining, I think, what you're describing as the legal analysis? I think it was being put by the other side that why wouldn't it be objective common intention unless there's a real policy biting against applying objective common intention to the question of analysis?
Well, if you start looking, I think the difficulty is if you start looking at policy, then the reason why these things are relevant is I think, should be almost always how it interacts with a statute, for instance, tax or the statute of frauds or whatever. So the policy is not, if you understand me, we're not looking at the position between the parties. This has nothing to do with the position between the parties or the commercial position, because that is determined by what they agree. They can agree what they like. We're not interfering at all with what the parties want to agree.
So we've got no statutes in place here.
Well, we wouldn't be arguing about it.
Well, we might be, because I think we've got, on the face of it, a pure point of law, actually, as to whether the legal analysis, i.e., if you want to call it classification, but whatever it is, is there some point at which the law says whatever the party's objective common intention is in relation to whether there's a contract or a variation, the law decides. Now, what's been put against you is, as a pure matter of contractual principle, that should be determined by the objective common intention of the parties, unless you can provide a policy to counter it. Now, I'm putting to one side statutes that may help you to answer that, but let's assume there isn't anything.
Well, I think my point was that this is, if you're looking for the policy of the law in, for instance, consideration or whatever like that, then you will be looking at how it affects individuals. Is consideration a good idea? Does it cause problems in contracting, etc., or the other kind of rules you have for the formation of contracts? Is this a problem? Is it a problem? The case about whether you can vary in writing, and if you say you can't, all these kind of things, because they all affect the parties and commercial matters. The question we're asking here is a pure question of taxonomy. It's a matter of legal classification. It doesn't make any difference to anyone apart from when you get to tax or, in the past, the statute of frauds, etc. And no one has suggested that statutory context is relevant in determining whether it's a new contract or not. In fact, if you look in Morris and Barron, they don't pay any attention to the consequences of what they've decided. The consequence of what they decided was there was no contract. The original contract was rescinded. The new contract was unenforceable. The parties were left with nothing. They were completely sanguine about that because that was the result of the rigorous application of the principles that they established. So the difficulty I have, with respect, my Lord, is to ask a question about policy in a case where it doesn't matter to anyone, apart from where it affects third parties. And I say really that there is just a rule here. There's a rule of law or a legal conceptual rule as to whether you have one contract or two contracts.
What is the rule? What is?
And the rule is the rule set out in Morris and Barron, which is if the change goes to the root of the contract and is sufficiently great, then it is a new contract, and it may rescind the previous contract. If it's not,
the trouble with that is that Morris and Barron is littered with these references to the parties' intentions.
Yes, but that's
you're saying no. We put the parties' intentions on one side. We just ask ourselves,
yes,
does this go to the root of the contract? If it does,
that's because the parties' intentions, the way they look, what they mean by the parties' intentions, are those that are manifested by the two agreements that you're comparing. And they're looking at what's the party's intention. If you examine these two agreements, if one of them is so greatly different from the other, then the party's intentions are that they should be separate contracts, because that's what they've manifested that intention in what they've actually agreed. And they're clearly not asking what the parties actually intended, or we're not talking about what they wanted or what they subjectively were thinking.
Well, the acid test would be, I suppose, if the parties expressly agreed this is a variation, not a new contract. Would the law then say, no, sorry about that, it is sufficiently, goes sufficiently to the root that it's a new contract?
We would say it could, yes.
Yeah.
You would say it could what?
It could say, if it was the case, the law could say, despite the fact that you have expressly said this is a variation of contract A, the law could say, well, what you've done is actually to create contract B.
And why would the law say that?
Well, because the law has to decide whether something's a contract or not, a new contract, because the
parties have said it's not a new contract. So what is the policy of the law to override what the parties have agreed?
Well, because the question is arising in contexts where it is assumed by the legislator or wherever that there is an objective conceptual standard. I mean,
forgive me, you keep sliding between, as I understand the questions, as sort of questions of
if you're asking the policy
contract theory into let's compare that with a statutory scheme and the statutory scheme.
No, I'm not. I'm being asked the question, why does the law say that? And my answer is because this legal rule arises in these situations. I'm not saying that it's anything to do with the policy of statutes. I'm just saying that that's the legal rule about contracts. The difference between them will arise in situations where some external force has said something about contracts and whether there's more than one contract, because it can't arise between the parties, because they can simply agree what they like. They can agree the terms of the contract, they can agree anything.
But
It doesn't matter to them whether it's one contract or two contracts.
The premise of this issue is that it's to be decided purely as a matter of common law. So we're asking, why should the common law override? I give you the example of an express term that this is a variation.
Well, because
What's the policy?
Well, when we say common law, we have to mean that it's what the judges have decided.
Yes, absolutely.
And judges have decided this always in a statutory context.
Well, it needn't arise in a statutory context. There could be other contexts.
Well,
There could be a trust deed that says that benefits will be provided to someone provided that a particular contract isn't terminated.
But again,
the issue would then be, have they terminated the contract or varied? There's no policy
I accept that, but again, there's a third part. That's affecting a third party. It's not the party.
No, but it doesn't. It's not going to depend on a construction of the trust. Well, it might, I suppose, but let's suppose it's expressed in very neutral language, as I've just indicated. So it becomes just the common law issue, isn't it? Which, as I understood, is what it was agreed should be argued here.
But it's a common law issue which affects...
I still don't have an answer from you as to whether the common law says that parties can, in some circumstances, not agree to vary a contract, but must be taken
It does.
to have entered into a new contract. And if so, why?
Well, if you mean by that, do cases like Morris and Barron say that or have that effect?
You say they do.
I say they do. If you're asking why...
Which is your best case on that?
Well, I think probably Morris and Barron is.
Well, could you show us what you got the high point of that?
Yeah.
I would find that.
But I mean, all the other cases follow it.
Yes, but that's why I asked for your best case.
Yes, let's see. It's the first. Sorry. I was going to take you to Morris and Barron, but sorry, I shall do so now. It begins on 1242. And it's a very convoluted case procedurally. You may have seen if you've tried to read it. The judge decided the case on one basis. The Court of Appeal decided it on a different basis, and then the House of Lords decided it on a number of different bases between the different judges, but they all came to the same conclusion. So if we look first at Lord Finlay, there's a lot of stuff in this that's not relevant. There's a lot of discussion of older cases about one of the issues in this case was can you vary and or rescind a valid contract by a parole agreement, which is not enforceable. And the answer in the end was you can rescind it, but you cannot vary it.
Yes, because the new terms are not enforceable.
The new terms are not enforceable, but the rescission is valid in some way, but they decided it was. So the question then was this a rescission or was it an ineffective variation of the earlier contract, which had been partly performed and partly not. I think it was a sale of skins. And ironically, the defendants had already admitted liability for the first part of the contract, for the payment for the delivery that had taken place, which I think on the basis of the House of Lords decision was probably wrong, but anyway, they had already done that, so there was already a judgment for that. Because the question about invalidity or rescission didn't arise properly at first instance. It only arose really in the Court of Appeal. It seems like the judge decided it on one basis and then counsel stood up and said, I've got another point actually as well.
This is perhaps a bit of a long run-in.
Yes, 1253. It's the passage at the beginning of 1253, the bottom of 1253. I think that's the only part which Lord Finlay where he deals with this particular point.
He refers to the effect of the language and the basis on which all subsequent dealings and correspondence
Yes.
of the parties proceeded.
What they did, yes, thereafter.
He's not restricting himself just to the language.
No, you can look. He was looking anyway at the further, what they further said between themselves,
Yeah.
and then
At the start of that paragraph, I mean, he focuses on trying to identify what the parties intended. That
by
seems to be
looking-
what he's
yeah,
concerned with.
yes, but he was doing it by looking at that particular at what they did, what they said,
Yeah.
and then
That's what you do with all contracts, though, isn't it?
yes,
You look at if there's writing, you look at that in its context. If there are dealings and correspondence, you look at that
yes,
as well.
exactly. Yes. And then Viscount Haldane deals with it at 1259 to 1260. That's a passage that seems to be cited possibly because it's quite a short one elsewhere.
1260.
1259 to 1260, the bottom of 1259 to 1260.
That seems to be focusing on this distinction between whether you can have a parole rescission and whether you can't have a parole variation. I'm not sure that's helpful.
No, but it's the only passage I think where he...
And on any view, this case is heavily influenced by the statutory context in which it all took place. And this is as far removed from pure common law as you can get in a sense, because the statute intervenes bravely to cut down the freedom of choice of the parties as to the mechanism by which they can get from one set of contractual obligations to a different set.
Yes, I agree, but if there is any common law, it comes from this, because all the other cases cite Morris and Barron as being
But isn't the position this? If parties who are in a contractual relationship with terms, let's call them A, but they want to get to a contractual relationship going forward with terms B, generally speaking, the law will give them a freedom of choice as to what mechanism they use to get from A to B. They can either tear up A and throw it in the bin and write a whole new contract in the terms of B, or they can do what you see done in some of the appendices in this case. They can say, well, that bit's changed by putting that in, that you take that bit out, you alter that bit, and quite obviously what they're doing is the mechanism of variation, as was done when the Golden Contract was made by a series of sophisticated alterations to the JCT standard forms. Now, no one would doubt that that process was a process of variation. Equally, if they'd simply torn up the JCT contract and said, we're not doing a JCT contract, we're going to have our own bespoke contract, that would be a fresh contract. But there may be, but the parties may not just, by doing one, let's say, vary, and then calling it a fresh contract, the law will not necessarily recognise the name or the label which they've given to it as prevailing. But and there may be some statutory situations in which that freedom of choice is cut down, as indeed it is in Morris and Barron.
Well, yes.
Can I just show you the other? Complicated than that?
Can I just show you the other passage? Well, the problem with that is that there are, as I've said, hundreds of statutory contexts.
Yes.
Talk about, but they only refer to whether it's under a contract entered into on a certain date. So, if it was to be said, well, the parties can determine that themselves, whether it's a new contract or a variation, just by saying so or intending it, then all of these provisions would be based on a complete misapprehension as to the law.
It
and would have to be
provision by provision, because some may, on proper construction, in effect reserve to the parties their freedom of choice. In other words, if the legislator is neutral about it and the parties have chosen a particular form of change, it may be that on proper construction the statute is fine to accept their choice, but there may be other statutory contexts where the statute is more directive as to what will count and what won't count and doesn't leave the choice to the parties.
I'm not sure how you would determine that when they all, in my experience, say the same thing. They apply to contracts entered into after a certain date. I mean, that's just normal statutory language.
In your written case,
anyway.
I think you gave the example of the Unfair Contract Terms Act, which applies to all contracts entered into after a particular date. You said, well, you can't get round that by saying, actually, our contract is a variation of a contract that was entered into before that date. Otherwise, it would be easy to avoid the application of that. So that is, but I think what you're saying is it's very difficult to find one of these cases which is devoid of context which points to an answer, because if there is no context, it doesn't really matter. It only matters, and that's why there's been litigation about it, because of some external norm which depends, the application of which turns on this point.
And you find some cases, well, Morris and Barron, I think, is an example where, at least on the face of it, they're completely ignoring the statutory, in the sense that they're not trying to achieve any particular purpose. They're aware of the statutory context, obviously, but they seem to be deciding the question as a kind of pure question of law, and then whatever the consequences are. And then you have a case like Shakur, where it appears that Lord Devlin is doing something different. He's looking at the consequences of the two different results, applying the Money Lending Act, and saying which of these consequences is the nearest to what the parties intend. So there's quite a different approach in these two different cases. And then you have Street and Mountford, where Lord Templeman expressly says that he's rejecting the argument that you take account of the statutory context of the Rent Acts. He says he's deciding this question as a pure question of common law. Indeed, he relies on a lot of cases in the 19th century, which were years before the Rent Acts. So some cases they seem to say we're deciding this without taking into account statutory context, at least they say so. And then, well, Shakur seems to be an example of a case where the opposite seems to be happening. But if you look, for instance, can I just take you on to Lord Dunedin, because he's probably the clearest in stating what he thinks the distinction is. At page 1266 to 1267, he just right at the bottom of 1266, where he begins, "My lords, I find myself unable to subscribe to this view. The difference in variation and rescission is a real one." So he does seem to be adopting some kind of quite mechanical test. And then Lord Atkinson at 1274. The paragraph at near the bottom, 1274, it's quite impossible.
Sorry, I got the wrong page. What was it?
1274.
Thank you.
But I don't understand why, if you varied the contract, it doesn't matter how inconsistent those varied terms are with the original contract, because whether it's varied or a new contract, those still replace the old contract. So under either scenario, there's no question of them still performing the obligations under the original unvaried contract. So I don't see why this
Yes.
works.
Well, it could be said, of course, also that what they're addressing here is maybe a different question. Is a question of whether there's a rescission
Yes, absolutely.
or a variation.
I was reading both the last passages.
That's the question.
Well, this is on the question of precision. They've already decided, I think, that the variation doesn't work.
Yes.
And so you're just then left with what is the legal effect of the new terms that have been put forward, which don't have contractual effect, but which in themselves sufficiently indicate that the party doesn't wish to proceed with the old arrangement. Exactly. And then you step back and say, well, they've sufficiently indicated they want this contract rescinded, and they were entitled to do so because there had been a departure going to the root of the previous agreement.
And the same doctrine arises under wills. If I make a second will, is mine, usually that connotes an intention to revoke the first one, but sometimes the court concludes that that intention is conditional upon the second one being valid. And that's the sort of ballpark we seem to be in Morris and Barron.
Yes. And I think the problem may be that all of the cases after that on this kind of issue have all simply quoted passages from Morris and Barron and taken that as being the test that you apply in deciding whether there's
intention is still relevant in relation to rescission because the party receiving the notice of rescission needs to understand all bets are off with this contract is at an end.
Yes.
And I think you look at that objectively, I would have thought.
I think by rescission here, they're actually not talking about that kind of, maybe my lord, they're talking about what they mean is simply terminating the contract.
By agreement.
But by bilaterally, yeah.
Oh, bilaterally.
Bilaterally. What they're talking about, have the parties, it's not rescission in the equitable sense. I think there's a different sense in which rescission is used. I think all they're talking about here is, have the parties agreed to bring this contract to an end?
Yeah.
Or not.
I mean, it's important in Morris and Barron to remember that there was no express variation of the original contract. What you had was the original contract. You then had the settlement agreement, which was evidenced by the letter but not signed by the parties. And the two were wholly inconsistent.
Yeah.
So the result had to be that the first one, the original agreement had gone. There was no more than that.
Yeah.
Unless you could have conjured out of the second one a common intention that the first is only got rid of if this is valid.
Yes, but
needless to say, parties who don't have to jump over many hoops to make it valid tend not to have any terribly discernible intention about that.
Yeah, because they don't care.
And there was nothing invalid about the settlement agreement. It was just unenforceable.
Oh, right, unenforceable.
Yes. If it had been invalid under the statute of frauds, the case might have been differently decided.
But of course, it was a settlement agreement of a dispute about the first contract. So I think that was what influenced the court.
Indeed.
The first contract to be brought to an end. I agree.
Yeah.
No, I understand. I agree with all of that. But I think the problem in then analysing what the common law is that all, as I said, all the cases then just seem to follow Morris and Barron as if it were the law. So,
but you agree with, I mean, the Court of Appeal here seems to have relied on Justice Lewison at least, relied on a common law principle that says that there is a limit to how far parties can consensually vary their existing contract.
yeah.
And as far as have currently seen, I'm not sure if one puts aside the Street and Mountain type cases, whether there's any authority for that proposition other than what we've looked at.
Other than Morris and Barron and the cases that have applied it. Well, I don't think there's any other line of cases on this question about.
Still less any cases where what the parties actually thought they were doing was neither a variation nor a rescission, but simply the working out largely by one party in the other party's silence of rights believed to exist under the first contract.
Yes, I agree.
Yeah.
Yeah.
I mean, your best point is what Lord Sumption said in Believe-In, isn't it? Is there anything better than that for you?
No, but I suspect he was probably following this line of cases as well.
He may or may not. I mean, but I mean, he certainly thought there might be some, as it were, long stop position where the law would say it doesn't matter what the parties say. This is a new contract.
Yes.
I think that's consistent with this line of authority. Maybe, yeah.
I mean, in effect, it's the point the law's prepared to be an ass, but only so far. I mean,
Yes. Yes. But I'm sorry, it may not be a great help to you, but that's this rightly or wrongly, this is understood in other cases to be a statement of principles in relation to whether there's a variation or not. I quite understand that it's not actually addressing the question of whether there's a new contract or whether it's a variation, which possibly may be a different question. Whether what you've done
Addressing it. That
wasn't
was the
addressed.
very issue.
Sorry?
That was the very issue in Morrison Barrett.
Yes. But,
Was this a new contract?
well, no, they didn't have to do no, because whether it was a if it was a new contract, it was invalid. It was unenforceable.
That was the point.
Yes.
So
they
it
didn't
was
have to-
neither the old contract nor the new.
Yes, but they didn't have to decide whether it was a variation of the first contract, which was also invalid, or a new
If it was
contract.
only a variation, then the old contract would have been still enforceable.
Oh yes, yeah.
So it was the very issue in the case.
Yes. So I suppose it follows if there was a rescission, there must be a new contract that came.
That's exactly right. I mean, what Lord Haldane says, well, they all say, really. Lord Haldane is quite explicit that he's looking also at surrounding circumstances.
Yes, but of course in this case, it doesn't necessarily follow that if they brought a new contract into existence, that they were necessarily rescinding or terminating the other contract. It's not necessarily part of the argument.
No.
It doesn't matter.
No.
Well, in fact,
It's maybe a slightly different question.
well, because DC1 was still under construction
Yeah.
under the golden contract.
Yeah.
Well, that's arguable. That hasn't been decided yet because that's DC1 is being litigated.
Yes, but assuming that
Assuming
that
it
was
was.
legitimately done under the golden contract,
Yes.
then what my lady
If it
says
was,
is
then-
correct.
Yes. But on any view, the golden contract could still have existed
Exactly.
and been used at some point. Yeah. So I think I'm not sure I can take this. I mean, the other cases, as I say, do simply
I
apply.
mean, despite all our interruption, Mr. Hewitt, you haven't managed to run the full period.
Try.
That's not a criticism.
I'm quite used to this kind of, I'm afraid. It's exactly what you want, really, as an advocate. So I don't think there's anything, unless I can
Yeah, thank you.
assist in any other way or answer any questions. Those are my submissions.
Thank you very much.
My Lady, my Lords, I was going to begin with what we've called issue 3. I think my learned friend has called it issue 1, and I apologise for that. And if there is enough time, then to make a few points about what we've called issue 2, which is the common law intention point rather than the clause 12 point. I'm going to say no more about the clause 12 point. So starting...
There is one point that Mr. Hewitt made about it can't have been clause 12 because they reduced the contract price. And that's not permitted.
Can I come to that? And I
Yes.
will, because in our respectful submission, the fact that they had a provision relating to the contract sum, well, I'm dealing with it now, actually. They had a provision in the contract dealing with the contract sum, which under the agreement did not change, regardless of any changes that you made in the employer's requirement, regardless of how different the contract sum was, i.e. an increase as well. But the provision in the contract sum, the definition of contract sum in the contract stayed exactly the same. And then you rely on clause 12A in the event of a dispute about any further contract sum which would be paid. And you
but I thought that was part of Mr. Hewitt's point, that
if I can just...
you couldn't sort of change things to the extent that the
contract sum stayed the same.
Would be paid less.
It stayed the same regardless, even if it went up. The definition of contract sum stayed the same, but you got more money because you had changed the employer's requirements in a way which, if I can just finish the point, if I may, you changed the requirements, so the employer's requirements were greater, and the definition in the contract stayed the same of contract sum, notwithstanding it was plain. In a sense, because of your change in the employer's requirements, you had falsified the definition in the contract. In a sense, that's what I'm saying happens with the definition of works. You can change the employer's requirements unless there's some restriction on the employer's requirements that you're allowed to change, which is implied and would have to make sense, obviously, as we all know. English common law will not allow, or contract law will not allow a contractual interpretation which doesn't make commercial sense. So it has to fit in with the words, and I mean, if it doesn't make commercial sense, it's unlikely to have been what the parties intended. On my learned friend's case, as I've sought to suggest, it doesn't make any commercial sense because you can change just about anything, except, for example, that it has to be 8 inches because that's part of the definition of works. So that's my first point. My second point was, if you change the employer's requirements, including those that go to the description of this as a particular factory to produce something else, inevitably you're going to have something that is, the definition will have to change necessarily, unless you're saying there's some employer's requirements that you can't change. And the point I wanted to make, I don't want to get caught on this again, because I think it used too much time in my opening, is this is not a perfect contract. And just like the definition of contract sum, where it was obvious it was going to change, and the terms of the contract did not allow a change, it was always going to be the same. In my respectful submission, exactly the same things happens with the definition of works. It can change, and it's necessarily and inexorable, and you're not locked into, in my respectful submission, a situation which produces absurd outcomes. I'm not going to say any more about that.
Can I ask my question?
Yes, you can. I'm sorry.
To it? Because as I understood your argument on freedom to change employers' requirements as feeding back into definition of the works, there was freedom in the employer to cut down or by changing what was going to be built. And I understood the force of the point being put against you in terms of the contract sum, that you can never reduce that. That's always going to be due and owing, as then indicating that there must be some limit in the freedom to change, i.e. reduce requirements under...
I don't accept the point, which is that you can never reduce the contract sum. Clause 12A(3) allows for a discussion about what the contract sum should be. And in my respectful submission, if you're building something which is half the size, then the consequence of clause 12A(3) might be that you pay a lesser contract sum. I really, if I may, just not get caught in that now, because in the time I have, I do have to get through that.
Yeah.
Can I go to issue 3 then? Issue 3 is the statutory interpretation point. My lady, my lords, although my learned friend's submissions moved around somewhat, it did seem to us that by the end there were 2 different points that appear to have been taken against us on issue 3. The first point, which I think was initially raised by the court, is that if a golden contract is varied after the 10-year period and expenditure is incurred thereafter, then that expenditure is incurred under the contract which affects the variation and not under the original contract as varied. So you have a contract, there is a variation, and the argument that was put against us is that if the variation gives rise to expenditure, then that expenditure rises not under the contract as variation, contract as varied, but as the contract which varies.
I think that puts it in a rather more extreme form than certainly I had in mind. I think if the contract is varied after the 10-year deadline, then you've got to ask in relation to your expenditure, is that being incurred under the original contract, unaffected by the variation, or is it being incurred by the varied part? In other words, you look to see where do you find the contractual obligation to incur the expenditure before or after the 10-year deadline.
I think that may come to the same thing, but
Well, it may do, but it's not quite as extreme as the way you put it. No doubt forensically for very good reason.
well, if I can just make the points, then you can tell me why they are wrong, perhaps. So I'm going to call that the timing point, because in a sense it makes a point about when did the variation take place? Was the expenditure incurred under which you can call the contract doing the varying, as opposed to the varied contract? So if I can call that the timing point, although I think my learned friend confirmed in response to my Lord Briggs during the course of his submission that he doesn't actually take the point in the way that I framed it, but I am going to address it just because it has been a point which has emerged from the court from time to time. The second point, which is the point raised by the commissioners or the revenue, is that even if the expenditure is incurred under the original contract as varied, Section 298(1)(b) doesn't apply unless the building constructed is the same building as that provided for in the original unvaried contract, or, as it was put in the course of argument as we moved on, unless the building constructed falls within the envelope of the contract. I think that's where we had this expression envelope of contract coming in. I'm going to call that the envelope point, if I may. Now, we respectfully submit that both limitations are wrong, not supported by the words, and with respect don't make sense. I'm going to just address those now. The envelope point first, if I may. We make 2 points about that. First, on the envelope point approach, the outcome would vary according to the existence and width of a unilateral variation clause. If Clause 12 or its equivalent had been so widely drafted as to permit virtually any change, then allowances would be available. But my lady, my lords, there is no magic about a unilateral variation clause. The reason why they are effective is the same reason why a consensual variation is effective, namely that both parties have consented. The only difference is that with a unilateral variation clause, such as the right of a lender to change the interest rate, the counterparty consents in advance rather than at the time of the variation. And we respectfully submit it would be very surprising if the same change is treated differently under the statute, depending on whether the counterparty consents in advance or consents at the time. Indeed, that is perhaps best illustrated by the example my Lord Richards gave of a building contract to build such buildings as the developer may specify up to a certain value, in relation to which I understood my learned friend to accept that allowances would be available, even though there is no commitment during the first 10-year period to any specific building. Secondly, even in relation to a bilateral variation after the 10-year period, the learned friend, I think, accepts that a building may be within the envelope of the contract, even if some changes are made, so long as the changes are not substantial. It is not clear what that means or where the qualification of substantial comes in. Presumably, however, the learned friend would say that if all you're including are a few windows, that would be within the envelope of the contract, despite it being a variation after the 10-year period. Would it, for example, include an extra room or an extra floor? And if an extra floor, what about another building smaller than the extra floor next to the building, but connected to it? What if it's not connected to it? In any event, and whatever my learned friend might have said about this, or what he suggests might be the actual position about what is substantial and what isn't substantial, this will inevitably mean that a factual question would arise about whether the changes are sufficiently substantial or not to fall outside the envelope, whatever that precisely means. And we respectfully submit that two things follow from that. The first is a point that my Lady Rose put to my learned friend, that the revenues construction gives rise to uncertainty. It introduces, by way of implication, something which gives rise to uncertainty. My learned friend's response to it was to be very sanguine about that and to say that there are many things about this legislation that are uncertain. But that, with respect, is not a reason to add them, and in our respectful submission, it is a reason not to add them. And we rely in that context on the judgment of my Lady Rose recently in the Fisher case, Fisher and the Revenue, paragraph 76, letter F. I'll give you a reference, page 1872, emphasizing the importance of avoiding uncertainty in tax legislation. The second point that we respectfully submit follows from a learned friend's acceptance that a bilateral variation may be within the envelope of the contract, is that it is, contrary to what he submitted, not a pure point of law. It certainly gives rise to something which is not a pure point of law. It would give rise to additional factual issues, as to which the upper tribunal did not make any findings. They weren't asked to make findings, and they didn't make any direct findings at all, which would be as to whether DC2 is the same building for the purposes of the statute, substantially the same, or however you want to put it, as that provided for in the Golden Contract, or within the same envelope as the Golden Contract. And even on the Commissioner's case as to the correct interpretation of the provision, that, on their case, involves a question of degree, rather than a bright-line rule. And it is one that may require evaluation. It may even require expert evidence. But because we don't really have a formulated, in a sense, implication to test, I can't say whether it would involve expert evidence. But of course, given that this point was not in play at all before the upper tribunal, and no evidence on the issue was led, it is also now too late to do so without a further trial. So it's not just the judicial review point that underlies our procedural objection, it is also that this is not a pure point of law at all, and it cannot be raised for the first time on appeal in this respect. Now that is what I wanted to say about the envelope point. I'm going to come back, if I may, to the timing point. Now we say, with respect, that there are three reasons why this does not assist my learned friend. Timing point being, again, was the expenditure incurred by way of the contract varying the original contract, or was it incurred under the contract as varied? That's effectively what it comes to. It's a very fine distinction. Now, we say this. First, to the extent that this point depends on the fact of the variation rather than its extent, than its content, it would mean that allowances might be lost if there is any variation of a golden contract, no matter how minor. I could change the wood on the windows from teak to mahogany. I could change the number of doors. If the golden contract entered into in, say, year 8 provides for the construction of an office block, but in year 14 the parties vary the contract to add 2 windows or a canteen, or even different wood in the windows, and the building is then constructed, the allowances on this argument would be lost, because it would be said that the expenditure was incurred under the contract that affected the variation, and not under the original contract as varied. And we respectfully submit that that is unlikely to be what Parliament intended. Secondly, this, we say, is also contrary to the Revenue's own construction of the legislation, which it has adopted and communicated to the industry for nearly 30 years. That is to say, variation in some way endangers your ability to claim some parts of the expenditure. Now, the court may recall, more likely may not recall, that the industry body, the EZPUTA, agreed certain arrangements with the revenue in 1994, which gave rise to our successful judicial review claim in the upper tribunal concerning the quantum of the allowances. That, for the court's note, is dealt with from paragraph 292 of the upper tribunal judgment, page 228. Those arrangements envisaged that a golden contract could be varied after the 10-year period, provided it did not result in the rescission of the golden contract, which is effectively what we thought we were arguing, certainly before the upper tribunal. And that is summarized in paragraphs 321 and 322 of the upper tribunal's judgment, just for your note at page 236. That refers to a letter from the revenue dated the 11th of November 1994, recognizing that allowances may be available even if there is a bilateral variation after the 10-year period, and suggesting, at least by implication, that this turns solely on the common law test. Now, I obviously appreciate, my lady, my lords, that the revenue's guidance cannot dictate what the legislation means, which is, of course, a question for the court. But the court, we would respectfully submit, would not likely wish to overturn what the industry had been encouraged by the revenue for some 30 years to understand the provision to me. And, of course, the revenue's guidance is also relevant to our procedural objection.
I'm so sorry, can you give me that page number again? I'm not finding it.
Page 236. Is that
236?
236 of the upper
Oh, the core.
paragraph 321 and 322.
Okay, I'm in the wrong bundle.
As I say, the revenue guidance is also relevant to our procedural objections, which the court has. The third point of the three I identified is that there is, we would respectfully submit, a linguistic problem with the argument as well. There is a distinction between the contract which affects a variation and the contract which is the subject matter of the variation. That's to say, the original contract which is varied. You have a contract which affects the variation, and you have the contract which is the subject matter of the variation, the original contract that is varied. Now, for simplicity, I'm going to call those contract 1 and contract 2. So contract 1 is the contract which affects the variation, and contract 2 is the contract, the original contract, which is varied. The timing point, as we understood it, was that the expenditure might be said to have been incurred under contract 1. That's the contract which affects the variation. But even if that is correct, it does not follow that the expenditure was not incurred under contract 2. If contract 2 was varied rather than rescinded, then plainly contract 2, as varied, required the builder to incur the expenditure. And that is sufficient for our purposes, because that would be a contract entered into during the 10-year period under which the expenditure was incurred. Whether it was also incurred, if that's the right way of looking at it, under or by reason of another contract is, with respect, irrelevant. And that was all I was going to say about issue 3. Can I then move on to say something about the SDA? And that's obviously a point which arises under issue 2. And there are 2 points which we would respectfully wish to make, if we may.
Sorry, just before you move on, I'm sorry to take you back. Can you just run the linguistic problem again? Sorry, I may have got the contracts the wrong way around. You're saying the contract which effects the variation is contract 1, the original contract is contract 2.
And I should have put it the other way around. The first contract in time.
Yes.
I'm sorry about that.
Yeah.
This was done very quickly, and I apologise. It should have been the other way around.
But the point you're making is that the expenditure that is incurred can be said to be under either. Is that the point?
Well, it may arise by reason of the second one, but it is certainly incurred under the varied contract, because that's the effect.
The varying contract and the varied contract.
That's with respect to
So it's certainly happening under the varied contract.
Yes.
Exactly.
Which I think is your contract
exactly,
too.
Exactly.
Yes, thank you.
All
That's,
right.
that's what I thought it was.
The varied contracts. I apologise for that. So the SDA, and we have 2 points here. The first point is this. My learned friend suggested this morning, I think in response to a question from my Lady Rose, that the £54 million, which relates to the expenditure incurred, was attributed to the consideration under the SDA. Can I just invite the court to go back, and I do apologise for taking you back to things that I've already shown you, but this I think may be worthwhile. Clause 2.5 in the SDA, page 668.
Yes.
Now, as the court will recall, this says the developer has, prior to the date hereof, paid to the principal contractor the sum of £54 million odd pounds, being the total amount due and owed by the developer to the principal contractor, pursuant to the principal contract. And then you get clause 19.1g, which is at page 693. Probably worth starting at 692. The developer represents and undertakes the owner as follows. You just may want to note in passing E, the principal contract was entered into on the 16th of February, being not more than 10 years. And then you go over the page to G, so this is the warranty that the developer is giving, that all expenditure which has been incurred by the developer in connection with the property, the building, or the building works has been or shall be incurred under the contract referred to in clause 19.1e. In my respectful submission, that is conclusive of what that clause 54 million pounds was incurred with respect to. It's not attributed to the SDA's consideration. With respect, that is well, to give an inaccurate description of what is happening here. The only other point I was going to make relates to clause 14.7. I think it is worth going back to. My Lord Burrows asked me about it yesterday. Can we go to page 680? I'm conscious I'm running out of time, and I apologise. Page 682. Just to have a look at it again. So the principal contractor, that's the contractor, shall at its own expense carry out or procure the carrying out of shell works and the fit-out works. And then if you go down, you see D, in accordance with, over the page, little 3, the principal contract, which of course is the golden contract. And what is actually happening here?
I'm awfully sorry, we're on page 682.
Yes,
you've just read from
14.7.
7.
And then you go down to D, 14.7. I mean, look at the whole.
Yes.
But in particular, we would emphasise D. There are various things he has to do. He has to ensure that it's all done properly, as specified, in accordance with an environmental report, and then in accordance with certain things, such as Acts of Parliament's approved plans, the principal contract. So what is actually being built is being built in accordance with the principal contract. And the reason that clause 14.7 starts by saying the principal contract shall at its own expense procure is, of course, because the principal contract has been paid 54 million. Mm. And what is actually happening in this contract is not what my learned friend says. It's
carry out or procure.
Beg pardon?
It says carry out.
Carry
or
out.
Procure.
Exactly. What is actually happening here is you have the principal contractor having been paid pursuant to the golden contract, which is obviously quite important that it still exists. Certainly the parties think it still exists because they want everything carried out in accordance with the golden contract, plainly as varied. But what also matters here is that, what is also happening here is that there's going to be subcontractors which are going to be employed. The principal contractor has been given all the money, which is the expenditure incurred, And he has to, out of that money, at his own expense, because he's now sitting on the 54 million, pay the subcontractors. And the shell contract, which you've seen referred to, is a contract which will be made between the principal contractor, who's procuring the carrying out of the golden contract, as varied, making sure that the subcontractors, what they build, is in accordance with the principal contract. So the expenditure...
In accordance with all this whole long list.
Indeed, but the only contract you'll find there is the principal contract, which is going to determine, and the shell contract will be what is entered into with the subcontractors.
So you say that's all to do with ensuring that subcontractors carry out in accordance with the
Principal
requirements
contract.
laid down.
Exactly. And it is simply wrong, with respect, to treat this as the contract under which the expenditure was incurred. And we say this is consistent with the golden contract being the contract under which Data Center 2 was built, and the SDA being the contract under which Data Center 2 was sold. We're selling something, and these are provisions to ensure that what is being sold is what you've promised to sell, which is what is built pursuant to the principle, to the golden contract. That is all I was going to say about the SDA, unless there's anything else the court wants me to deal with. Can I just say one other thing about exhaustion, which has come up a fair amount in...
About the...
Exhaustion, the point about
exhaustion. Yeah.
It's, and I think this may be to go over old ground, and if it is, I apologise, but I just want to be clear about this. When I opened, I said there were two senses in which exhaustion may arise. One is that the work's completed, which is possibly the Lord Justice Lewison point, possibly not. The other is that all that's happened is there's been an exercise of a right, and it's then suggested that because you've exercised a right in circumstances where it hasn't been completed, the mere exercise of the right constitutes exhaustion. In its stronger form, which is Lord Justice Lewison's form, you can't vary. In its weaker form, which is the Lord Justice Newey approach, it counts strongly. Indeed, it's the only thing, I think, which is said to count against the intention which you derive from the, I'm going to call it the tax objective. And can I just, without spending too much time on it, just test that point in this way? Suppose on one day, suppose I exercise a right, and one day, well, there's a change order given. One day after the change order has been issued, the parties had agreed by consent a variation to the golden contract, and let's say they agree it expressly. In our respectful submission, there's no conceptual reason why there can't be a variation just because I exercised my right the day before.
The variation being, we thought this was just going to be for one project, but
and you
now
put
we
another
agree
one.
It can be for two.
Exactly. I said one, please make it two. In our respectful submission, it cannot be right to say that it can't be a variation, nor in our respectful submission does it dislocate, dislodge, overrule, override the intention, the tax intention point. Can I then just say this? On the subject of intention, one thing I didn't do was to take you through clause 4.2 because I ran out of time. There is an argument about clause 4.2 which is in our written document. If I can just show it you, I'm not going to show you the arguments because I don't have time, and it's controversial, so I'm not going to spend time on it. Can I just show you clause 4.2, which is at page 350? And I should acknowledge we didn't run this before the Court of Appeal. It was not an argument run before the Court of Appeal.
This is the JCT terms, isn't
In the JCT terms. So upon receipt of what purports to be an instruction issued to him by the employer, the contractor may request the employer to specify in writing the provision of the conditions which empower the issue of the said instruction. The employer shall forthwith comply with any such request, and if the contractor shall thereafter comply with the said instruction, neither party before such compliance having invoked procedures under this contract relevant to the resolution of disputes or differences in order that it may be decided whether the provision specified by the employer empowers the issue of the said instruction, then the issue of the same shall be deemed for all purposes of this contract to have been empowered by the provisions of the conditions specified by the employer in answer to the contractor's requests. Now, there is a debate between the parties set out in the written cases about whether this can only ever apply in circumstances where there is a receipt of what purports to be an instruction and the contractor does request in writing some clarification of the power under which this instruction is to be given, and then decides to proceed. And Miller and Friends say it's only, they didn't go through that process of asking. We say, well, they didn't need to because everyone knew it was clear, it was specified what they were relying on, i.e. they identified the fact that they thought this was a clause 12 point. And I'm not going to get into that debate, it's set out in the written documents. But what in our respectful submission is clear from this is the intention of both parties that in circumstances where an instruction is given, which may or may not have been valid or within the contract, and the contractor is content to proceed on that basis, it is to be regarded as a contractual instruction. I'm being told that page 397, there's some deletions from clause 4.2. Do they matter? And we rely on that in the context of the intention point. Obviously, what was the intention here? These were parties who had expressed the intention and indeed agreed that in circumstances where, leave aside the technical argument, the overriding intention was in circumstances where an instruction had been given, which may or may not have been strictly in accordance with the instruction, if the contractor was content to proceed on that basis, it was to be regarded as a contractual instruction. Now, in our respectful submission, that bears on the question of whether there was or wasn't a variation or a new contract. I'm not going to spend any more time on that. It may also be relevant. In a sense, it's a contractual recognition of the shoe care point.
Mr. President, I'm sure you know that your reply time doesn't get extended.
No, I do, and that's why I'm stopping.
Yes.
I was going to stop unless the court had any questions for me.
No, thank you very much.
Thank you.
Well,
I just wanted to say, as a point of information, we have provided the Court of Appeal's skeleton that.
thank you.
And I'd forgotten there is quite a detailed appendix dealing with the procedural point in that skeleton.
Thank you very much.
Yes.
Well, we are most grateful to the parties, council, and no doubt the enormous amount of preparation work that went on by other members of their teams for presenting us such well thought out and carefully prepared arguments. We're particularly grateful that Council have borne with us with such fortitude our endless questioning, but as I said earlier, it's been of great assistance, and we will now go away and consider what judgment we ought to give.